Take 5, action.
Good afternoon. My name is Oliver Westmoreland. I am an IAA-registered Level 3 advisor and senior immigration lawyer with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is a story set in Birmingham, which, as you know, is the second city of England. It's about a man, Mr. Ahmed, a Bangladeshi national. He had a skilled worker visa as a care worker, and he hadn't yet started the job. He'd only recently come to the UK. He hadn't yet started the job, but he had a valid visa. He was walking around in Birmingham New Street Station. If you've ever been there, this is a real hub. It's got lots of trains, as you might imagine, going to the four corners of England. It's got pubs, bars, restaurants. It's very, very noisy. Most one of the noisiest places in England, probably. Anyway, he was walking through there for one reason or another. He was apprehended by some Home Office officials. They thought he looked suspicious. I think because he ran away from them, and it always looks bad, doesn't it? They apprehended him and they started questioning him. They thought, I think the way that they work, if someone runs away, I think they're probably guilty of something or other. If they look nervous, that's another sign of guilt. Anyway, they nabbed him. They sat him down on a chair in the station, which is, say, the noisiest place in England, probably. And they started interviewing about his immigration situation. They ascertained that he held a healthcare worker visa. They ascertained that he hadn't yet started the job. Also, they ascertained that he had been working in his uncle's restaurant. For the moment, for the time being, they thought they ascertained that he's being paid for it. Now, that is in dispute. He didn't say that. He said he didn't say it, but that's what they thought. Anyway, he was nabbed. He was taken away, detained. His leave was cancelled, and he was held in detention for several days. Mr. Ahmed was a bit unhappy about all this. He thought he'd been unfairly treated. He applied successfully to the High Court for judicial review. The High Court accepted his claim. It had some solidity behind it. Now, this actually happened in January 2024. These cases take a long, long time, but eventually got to the High Court quite recently. Judge said, first of all, that he wasn't convinced that he had been in breach of immigration conditions because of this, that, and the other. It hadn't been clearly established that he was in breach of conditions. He denied having been paid by his uncle to work in his restaurant. It wasn't proved that he'd been paid. A few other things as well. The judge said that he wasn't convinced that he was in breach of conditions. The judge was convinced that the interview was not proper. Sitting in the middle of a very, very busy terminus, being interviewed, all these quite difficult questions. And indeed, Mr. Ahmed, or his lawyer, said, well, is it really fair to have this sort of interview on this sort of serious subject right in the middle of a busy railway station? Judge said, no, it wasn't. This is procedurally incorrect, a procedural impropriety. This wasn't good at all. So it added up to this. Breach of conditions had not been established. Interview was very, very wrong. The procedure was wrong. This is a technical legal term of art, procedural impropriety. If you follow our blogs and vlogs, you know in the last few months there have been many cases in the High Court just on this issue. Not always about whether a decision was good or bad, but was the decision making done properly, fairly, legally correctly? Judge says most definitely not. So of course Mr. Ahmed won his case, and the decision cancelling his leave was quashed, and I'm sure that he can claim compensation for the unlawful detention. What I want to talk about most particularly is the difference in culture between a High Court judge and Home Office officials. complete difference in culture. Now, the judgment from the court is about 14 pages, quite extensive, voluminous and detailed. The judge quoted loads and loads of words from Home Office published policy guidance. Home Office publishes quite nice and complex guidance which has a sort of fair, nice, reasonable quality to it. The question is, first of all, do the Home Office officials, do they know the policy guidance? Have they read it? Or if they have read it, do they remember it? You see this different in culture, and you always see this. Nice English, legal, educated type judge goes through in depth and detail the policy guidance and quotes it at great length. And then he explains in which ways the Home Office officials did not follow their own policy guidance. This, and the other. I just want to quote, I'm not going to read the whole thing because we haven't got enough time, but I just want to quote just a few bits here. He was never given the chance to get any legal advice. Judge says this, paragraph 46. If it is intended to conduct in such public view and circumstances an interview of such significance, sufficient safeguards are necessary to ensure procedural fairness. Paragraph 47. At this point, with the knowledge and experience of procedure, process, applicable legislation and available powers, one must inevitably attach to those acting in the role of IEO, Immigration Enforcement Officer. Being at the very least superior, and like to be considerably superior to that of the claimant, that's Mr. Ahmed, officer blah blah, officer blah blah, should have paused and considered how to proceed to ensure fairness. And then further, to conduct questioning of the centrality and importance to claimant's immediate and long-term future, without any regard to the physical surroundings and their impact on the process, created, in my mind, procedural unfairness. This was an important thing here. This person's going to lose their leave, potentially may get thrown off UK. It's quite a deep, serious matter to him. And a few more interesting words, please bear with me. Paragraph 48. Following his early administrative arrest, the claimant could have been moved to a quiet, less public and more conducive setting with ease. No thought was given to this, according to the evidence. Paragraph 49. In the very specific circumstances of this case, only with sufficient knowledge and understanding of the gravity and situation and the opportunity to reflect on and communicate clearly whether he wished someone to be informed and to request this legal advice, could procedural fairness be assured. This did not happen. I have concluded that ground one, this is several grounds, ground one, on procedural fairness succeeds. Finally, paragraph 52, conclusion. This judgment is about the very specific circumstances engaged in this claim. This judgment is not intended to extend to all non-intelligence-led routine enforcement operations in public places, and there is nothing intrinsically unfair or unlawful about such planned operation. However, nevertheless, there is scope in such operations, as in any comparable situation, for procedural unfairness to vitiate the process, to mess it up. In my judgment, this is what occurred in the case with the interview. The claim therefore succeeded on ground one, and as a result, on ground three, the decision to curtail the claimant's leave will be crossed. Notice the judge's language is absolutely precise and thoroughly analysed. The way that Home officials behave is rushing through, not really thinking, not considering. I just want you to show this. It always comes across the difference in culture between the legally educated judge, educated in English law and all the principles that go with it, and the Home officers, not quite sure what they're educated in. I'm not even sure they're educated in their own policy guidance. Do you have any comments and questions, Mr. Shah?
This is a great case, and it shows how the Home Office approaches almost everyone when they are conducting such an operation, and how these cases can actually turn completely around.
Can I ask you a question? Does the Home Office read these court cases, and do they change their behaviour or methods?
I don't think so.
I don't think so either, but it's a fair question, isn't it?
It is, yeah. I mean, these should have an impact on how they conduct these operations and anything similar.
Maybe they're too busy doing operations.
Oh, probably. So this does show to the public that if somebody find themselves in a situation like this, it's not the end of the road. They should take legal advice. Maybe the Home Office has not followed their own procedures and can challenge them.
In many cases, it's going to be judicial review. In many cases, for the High Court. I think it's the High Court because there's been detention. As soon as the criminal has been detained, and it gets to the High Court, not the upper tribunal. But of course, everyone knows not everyone's brave enough to go to the High Court. Or after. If you lose your case, you might get hit by losers' costs. It takes a brave and determined person. You're not going to get legal aid for this.
True.
It takes a brave person. But the thing that you notice, that a lot of these cases are successful.
Great.
People say, "Oh, the courts are always against us." They're not. The courts are actually, these cases, the courts are very, very fair.
Very fair. Yeah, definitely. Great. So this really sums it up, and I hope the viewers will find it as interesting and insightful as I did.
Let's hope that they don't get into that sort of situation. But if they do, then maybe light at the end of the tunnel.
Great. We always end with hope, and that's the best way to move forward.
Absolutely.
Well, thank you so much for today's vlog, and we'll see you in the next one.
My pleasure. See you next time.